Things keep changing and never for the best, at least not for you. Rearranging rules that we cannot.
Okay, so some of the things we provide, and also some of the services I'm going to be discussing. MSAs, Medicare set-asides, evidence-based MSAs, CMS submission, future medical cost projection, claims settlement allocation, and MSA and EBMSA updates and revisions. Additionally, we're going to be discussing conditional payment and lien services as well a little bit later on. But the first thing, sorry, let me just exit out because things are making noises at me. Okay. So MSAs, as we know, it's a statement you get that basically has a complete breakdown of the future expected medical costs that a claimant is expected to generate. They list pre-existing conditions, comorbid conditions. They'll usually give a rated age, which will basically determine the claimant's expected or life expectancy based on those conditions. And it also typically identifies some areas that can be clarified, or that some potential issues that may come up if the MSA statement is submitted for CMS. Those usually are sort of red flags to us to act on, so that we sort of smooth the process of CMS submission. And then that's the point at which the attorneys will get involved. Once, when we get the MSA statement back, we'll be involved in identifying any mitigation potentials. For example, a common one is we've seen instances where the treating provider is prescribing a brand medication where a generic is perfectly acceptable. So we'll go ahead and identify that and work on getting the provider to substitute that out for the generic for cost savings. So we do things like that. We can also provide updates and revisions to MSAs that we've previously completed. I think MSAs are good for 6 months, and that's because CMS requires the most up-to-date medical documentation when they're reviewing a file, and that is that they require that within the previous 6 months.
And when we're doing MSAs, and this is Shannon, I'm co-hosting with Alexis, but she did all of the work. With these MSAs, we can also, other than cost mitigation, we can also identify potential pitfalls that CMS might come up with. I had a claim one time where the claimant had a back claim and had been taking gabapentin for 20 years for an unrelated neck condition. And the MSA pointed out that, our cost calculations were about $10,000, but with the gabapentin, it actually came up to $175,000. So we needed to submit to CMS approval with a letter from the treating doctor saying this gabapentin has nothing to do with this comp case on that letterhead, or else CMS might include that in their calculation. And once they calculate something, they're not going to come back. So it's also good to get those mitigation, not just mitigation of your actual cost, but mitigation of potential costs that CMS might make up.
That's true. Generally speaking, once you submit something for CMS approval, like, you better have your ducks in a row, because once you get that letter back, that's pretty much it. But they will review after a year. You can request that it be reviewed after a year, but that's generally only if circumstances have changed significantly within that year. But yeah, so there's the MSA we all know and love, and 99 problems. But the MSA won't be one. So here's how you work around all the common problems we see with MSAs. So I've asked around, and a lot of the issues we currently encounter is whether an MSA is even required, the CMS review thresholds, as I mentioned, the no reduction to generic versus brands for prescriptions, trying to get statements from doctors about the lack of a need for prescriptions, surgical procedures or other treatments, including sites for which the claim is not established, lack of clarity about how to reduce costs, no understanding about how rated age was determined. That one could be important because when you are allocating medical care for someone's life expectancy and the rated age gives you life expectancy, CMS wants to know how you determined that life expectancy, because if you miscalculate that, right, then CMS could potentially be on the hook for that. So they generally want to know how the rated age was determined, and we've seen a lot of MSAs in other places where that's not clearly, the methodology isn't clearly explained. Why do indemnity payments need to be provided? That generally just gives CMS an idea of the overall value of the claim, because that they take that into consideration when determining whether or not their interests have been reasonably considered. The amount of the, for example, if it's like $1 million settlement and there's like $1,000 allocated for medical, that looks a little wonky. So they do consider the indemnity amount, even though they obviously don't really have an interest there. Is there a reduction of present value, and how long is the opinion good for? Those are just some of the things we commonly come up against. Never Say Never. This is a great album, by the way. I recommend it. But this is the only time where you can say never. CMS approvals and MSAs. MSAs are never, ever, 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 ever required. Hold on, it's going too fast. Okay. MSAs are never required. Shannon, are MSAs required?
Never.
Great. So why do we get them if they're not required? They cost money. Why do we get them? It's very easy. It's because it takes the guesswork out of estimating the value of the medical benefits. And instead of just coming up with a number, we actually look at the case. We look at the medical treatment. We look at CMS guidelines. We look at generally accepted practices and standard of care. I mean, we look at everything and coming up with a reasonable value for an MSA statement. And having this document protects against the risk of CMS coming back later down the line and coming back to the carrier for additional funds. If you have a report justifying the amount of the medical expenditures, it's basically a way of mitigating risk. MSAs and CMS approval is all about your risk tolerance. There are some carriers who never get MSAs, they never submit to CMS approval, and they can do that, but they are courting a little more risk. Some clients, on the other hand, are less risk adverse, and they sort of want the maximum protection possible, and that is getting an MSA, having CMS review it if it meets the threshold. So again, it's never.
You can also take a middle ground too, where you get an MSA, but you don't get CMS approval. It's middle of the road risk.
Correct. I happen to be a poker player, so I like a little risk, but some of the clients don't. So you have to your recommendations are not only based on what you think is reasonable for the case, but you kind of have to consider your client's risk tolerance as well. So as I said, it's not required, but when is it recommended? There's two types of sort of circumstances under which it's recommended. The first one is where the claimant is currently eligible for Medicare, and claimants are currently eligible for Medicare when they're 65 years or older, age eligible, when they're entitled to Social Security disability and have been for 24 months or longer, disability related, and end-stage renal disease, which we don't really see very much of, but that's when the claimant is currently eligible for Medicare. It's also recommended if the claimant is expected to become eligible for Medicare within 30 months, and the estimated total settlement amount is greater than $250,000. We'll get a little bit more into that later, but when the claimant is expected to become eligible for Medicare within 30 months involves circumstances where the claimant's entitled to Social Security disability for less than 24 months, where the claimant has applied for Social Security disability and is currently awaiting a response to the application, and where the claimant has been denied Social Security disability but is appealing or refiling, which is essentially the same as applying for Social Security disability and waiting for an answer, a final determination, and when the claimant is 62 years and 6 months or older. So when the claimant is currently eligible for Medicare, the reason why that's important is because we've got this all-important act, the Medicare Secondary Payer Act, which basically, in short, says that if there's someone else who can pay, they have to pay. Medicare is going to be the second payer, and they only pay if there's no other entity that could pay. So in terms of workers' compensation, that means if workers' comp can pay for it, they're going to pay for it. Medicare will only pay secondarily. So given their status as a secondary payer, settlements that close out future medical rights have to give their interests a reasonable consideration in order to avoid cost shifting. If they think there's cost shifting, that's when they come back to you for reimbursement or additional funds. So the allocation reduces, an MSA allocation reduces the probability of Medicare coming back for that reimbursement, and it prevents the probability of Medicare making future conditional payments on the claim. And the reason why this particular category of claimants are so important to make sure you get the settlement right is because CMS has a current vested interest in that claimant, because either the claimant's a Medicare beneficiary, or they're currently eligible, in which case they're likely to become a beneficiary basically any day. So claimant or Medicare's interest is present. So you have to make sure to avoid any possibility of cost shifting. And the way you do that is by giving reasonable consideration. Now that's sort of a nifty word that lawyers sort of like to throw around when they don't really want to set too fine of a limit on what's considered reasonable. So they basically just toss that in there, and then they decide it on a case-by-case basis, so nobody has to like write down what that actually means. But we've sort of, there are sort of guidelines as to what is considered reasonable consideration of Medicare's interests. And the way you give reasonable consideration, you can do an under threshold, we'll talk more about the thresholds later, that are not submitted to CMS for review. Above threshold MSAs that may or may not be submitted to CMS for review. That's basically what Shannon was talking about, where you get the MSA but you don't submit it. It's sort of a medium risk. A compromise MSA, it's funded by the net settlement. You can have zero future treatment MSAs where the claimant's not expected to treat in the future. You can have an MSA that comes back at zero. It doesn't always have to have an amount in it, as long as you can back up that number.
I had a CMS approved MSA for $0 one time.
Yeah, it's like the rare golden egg. You want to jump on that, and CMS approves a zero sum MSA, you're golden. But so the selection of the best method is sort of done on a case-by-case basis. And then the second category is where the claimant is expected to become Medicare eligible within 30 months, and the estimated total settlement amount is greater than $250,000. That's where the indemnity value comes in, because you can have sort of, let's say you have the capped benefit that's, I don't know, valued at like $150,000, but you've got an MSA that's, you know, $200,000. The MSA by itself may not meet that threshold, but you count in the indemnity, the expected settlement amount is greater than $250,000. And if the claimant's eligible to become entitled to Medicare within 30 months, you're going to want to get an MSA.
And when you do that calculation, even if you split up the payment of the 32, where you have an indemnity only 32, and then months later an MSA, it's the value of the overall. You don't get to just take the value of each MSA as you go.
Yeah. So you can qualify for Medicare if you have a disability and you've been approved for SSD. In most cases, you need to wait 24 months before your Medicare coverage begins. It begins on the start of your 25th month. So at that point, you become automatically enrolled in Medicare. So that's why we like to know the claimant's Social Security status. If the claimant is entitled to Social Security disability for less than 24 months, there's still a reasonable expectation of the claimant becoming Medicare eligible within 30 months. And that's because, again, you're automatically enrolled on your 25th month. So if you've been on SSD for 6 months and you become automatically enrolled on your 25th month, then there's a reasonable expectation of you becoming eligible within 30 months. Applied for SSD and been denied SSD or appealing. That one's interesting because the claimant's not currently enrolled. You don't know whether or not it's going to be denied, but the reason why we like to submit that one for review is because let's say you have a claimant, it's a 5-year-old injury, and you've had the claimant who's been out of work essentially those 5 years, surgery after surgery. They're not at permanency yet, but they've been out of work for 5 years, and they have a pending Social Security disability application. That application could be retroactive to the beginning of their disability, or again, the 25th month. So if they've been out of work for 5 years, 25 months from the start of their disability, around year 2, they'll be eligible for Medicare. And even though they're applying in year 5, those benefits could be retroactive all the way back to the 25th month where they became eligible, which means at the minute they get that letter back approving them for Social Security disability, they're immediately eligible for Medicare. So that can be tricky because if an application is pending, the minute that application comes back, it could change the claimant's Medicare status almost immediately. So we like to have those submitted where we can to shield against that possibility. And then where the claimant is 62 and 6 months or older, and that's because that's exactly 30 months away from 65, and that's when the claimant becomes Medicare eligible at 65.
Back in my special funds days, they didn't necessarily submit in that time period, and I did have that happen where we were at a 32 hearing and the claimant had just gotten, like the week before, his approval letter for Social Security, and just based on their risk tolerance, which was no risk tolerance, we had to walk away from the hearing and go and pay 6 months while we got everything in a row in order to have CMS approval.
Yeah. So the CMS is recommended, but doesn't need to be submitted, or the MSA is recommended, but doesn't need to be submitted for CMS review. And again, seriously, I recommend this album. But here we say never again, because MSA are never required to be submitted to CMS, ever. You never, ever, ever, ever have to request CMS's approval to do an MSA. You never have to request their approval for any settlement, ever. So then why does everyone say that we do? Again, it's about risk. Having the very entity that could come back to you for additional funds tell you that your allocation was reasonable is sort of the best way of shielding yourself against them actually coming back. You say, no, you said that was reasonable, so get out of here. So CMS approval is the best way to shield yourself against them coming back in the future. So then why don't we have them review everything? Well, that's because there are thresholds. They're very slow. They're a very slow entity. They have a lot of claims to review. Everyone's wanting their attention. They're busy. So they're only going to review certain claims. And the thresholds are pretty easy to understand, but again, they're just thresholds. CMS review is never required, but if you want them to review it, they will review it if your claim meets these thresholds. And that's one where the claimant is currently Medicare enrolled, not eligible, enrolled, and the settlement is expected to be greater than $25,000. So if the claimant is on Medicare and the settlement is greater than $25,000, CMS will review your MSA statement. They'll review your settlement. Oops, hold on. Oh, too far. There we go. The other circumstance where they will review the settlement is if the claimant is not enrolled, but has a reasonable expectation of becoming eligible and or enrolled within 30 months, and the settlement is greater than $250,000. They'll review your statement. Keep clicking too fast, sorry. Okay, so again, keep in mind, CMS review is never required. They will review your MSA only if it meets those thresholds. So we get a lot of claimants attorneys who are like, you got to submit, we will only settle with a CMS approved MSA. If that MSA does not meet, or the overall settlement does not meet those thresholds, they won't review it. Push back on that claimant attorney. We're not submitting this for MSA, for CMS approval. They're not going to review it. A lot of attorneys also think it's required if it meets those thresholds. That's not true. Again, an MSA is never required. CMS review is never required. But if the claim meets those thresholds, if you want review, you can obtain review.
And sometimes you do have to fight with claimants counsels when they do meet that threshold in order to not get it reviewed. I've never had them actually walk away from a Section 32 because we didn't want to get it reviewed, but I have had them tell me they would. But they always went through eventually. I forced it.
Yeah, I mean, if you tell them if you explain to them or have them explain to their client that they're not getting a settlement because the attorney insists on something that's not legally required, it's pretty hard to explain, especially when you had this document that pretty clearly and correctly, we think, lays out the medical care. It's not like we're just skimping on the claimant's medical and saying we're not submitting this. We provided the statement we think is adequate. We're just not submitting this for CMS review. So then once you submit for review, what do they look at? They look at a bunch of things. One is the date of entitlement to Medicare. That just basically tells them, it gives them an idea of sort of how long you've been disabled or your age. It sort of helps them it puts the settlement into context. The basis for Medicare entitlement, again, that sort of puts it into context, because if it's disability related, you're generally expected to need more medical care than if it's just, someone simply reaching 65. These days, I mean, 65 is kind of the new 55, 45. You see people who are 65 out there running marathons. So, just reaching age doesn't necessarily implicate anything as far as disability. And then end-stage renal disease, which very expensive. But again, we don't typically see that. The
Well,
type
if your claimant is running marathons, we should consider a fraud claim.
Yeah, well, sure. I mean, you'd have to like probably have an investigator run alongside them and sort of keep pace and have the camera going while they're
I think
running.
we have a 5K one where James got fraud on a 5K, but that's a digression.
Did the investigator run the 5K next to the claimant?
I think we just had Facebook pictures.
Oh, see, no, I would want to be the investigator that just like runs the 5K with the claimant. That'd be fun.
I wouldn't want to run a 5K with anyone, but.
Well, that's why I'm the athlete. But they also consider the type and severity of the injury and illness, because again, that sort of gives some context as to what's reasonable, what's not. Like an ankle sprain would probably be worth less than a claimant who's had a lumbar spine injury with a lumbar fusion. The age of the claimant, and rated age. Again, we talked about that. The workers' compensation classification, a permanent total claimant is sort of viewed differently than a permanent partial. Prior medical expenses paid by the carrier, because again, if the carrier has been paying like 20 grand a year in medical expenses, but the MSA is sort of allocated at like $2,000 a year, that looks a little wonky. The amount of the settlement, whether the commutation is for claimant's lifetime or a specific time period. If it's not for the lifetime, you got to indicate why not, or the basis for commuting it to a specific time period. And whether or not the claimant is living at home or in a nursing home or receiving assisted living, because again, the costs go up. And whether the expected expenses for Medicare covered items and services are appropriate in light of the claimant's condition.
And yeah, and it is for Medicare covered items. That zero MSA with CMS approval I had, the claimant was entitled to some medical care. It's just that medical care was not medical care that was covered by CMS. So it was part of our negotiated cost, but it wasn't in part of a CMS or MSA calculation.
That's a good point. Okay, so we got the MSA. We frequently run into the question of how long is it good for? Hey, I've got this MSA from a year ago. Can we just submit that? Again, no, because it has to be recent within 6 months. CMS requires medical documentation to be current. They want the most up-to-date figures. And that you sometimes run into problems where, for example, once the claim is classified, typically treatment sort of goes down after the claim is classified. Now, I don't know this to be true, but I suspect it's because they ramp up the treatment to up their classification finding. The more they treat, the more disabled they look. Because it's like clockwork. Every time a person's classified or they settle the indemnity only on an agreement, somehow the medical just stops. So if you're at a point where the medical stops, but you are now closing out the medical, then you want to know, well, if CMS wants the most up-to-date medical treatment and the claimant hasn't treated within the past 6 months, what do we do? Well, you get a letter. You can get a letter from the treating provider. It has to be on their letterhead and dated, stating that the claimant is at maximum medical improvement and does not require future treatment. You submit that letter, you should be fine. You could also do things like have the claimant, or if you have a HIPAA, request the pharmacy printout. You can go to their pharmacy and just request a list of all prescription fills, for example, within the past 2 years. The CMS will also accept 2 years of records from their primary care physician. So there are sort of things you can do to work around it if the claimant has not had treatment within the past 6 months. So then what happens if none of that is applicable? The claim is not Medicare eligible, not likely to be Medicare eligible. I mean, say you've got a 25-year-old claimant who's not receiving Social Security disability. What do? Well, you still have to take their interests into consideration, particularly because that injury could be permanent. The claimant could become entitled to Medicare at some point in the future. you want to make sure that the whole point of allocating this medical in the settlement is to make sure that CMS, whenever they have an interest in the claimant, that they never pay for this workers' comp injury. So you still have to take their interest into consideration, even if the claimant is not currently eligible, not currently enrolled, and not likely to be enrolled. Because if that ever changes, you don't want CMS picking up the tab because they will come back to you. So in those cases, we recommend you can get two things. One is an evidence-based MSA, and the other is a claim settlement allocation. An evidence-based MSA is basically like an MSA. It's essentially an MSA, but instead of using sort of the very outdated guidelines in the workers' compensation Medicare set-aside arrangement reference guide, which basically is what Medicare approves and thinks is reasonable for treatment, which sometimes makes no sense when you consider the actual facts of an individual claim. An evidence-based MSA will actually look at the acceptable standards of care, updated medical practices, what's called evidence-based. We don't just follow some reference guide. We actually look at the evidence of the case and determine what allocation is reasonable for that claimant's Medicare. But it also satisfies your obligations under the secondary payer statute to consider CMS's interests. But again, it doesn't have to be submitted for Medicare approval. And in fact, we don't submit the evidence-based MSA for Medicare CMS approval because, again, it's not in compliance with Medicare's guidelines. It's evidence-based, so you would not submit that for CMS approval. As I stated, it's essentially like an MSA. It requires the same information as an MSA. We look at the most recent 2 years of medical records, the pharmacy history, the claims history, any recent medical reports, IME exams. We sort of look at everything. And then we come up with a future medical cost projection using certified life care planners. We use nurses. I mean, there's a whole bunch that sort of goes into this allocation using some very qualified professional individuals. And then the attorneys sometimes get involved as well. If once we get the statement back, we think something's a little off, we sometimes get involved as well. But getting the evidence-based MSA, it provides you with a defense because, again, it's not submitted, but if Medicare comes back and brings a claim against you later on, and you want to argue that, no, our allocation is reasonable, this document will help shield you against any allegation that the parties have attempted to unreasonably shift the cost to Medicare. And then these are typically professionally administered because claimants can't be trusted to spend the MSA funds reasonably sometimes. So
and sometimes it's not even their fault. I've had some claimants counsel have concerns with settlements recently that are full and final because claimants are coming back to them saying that their MSA or even CMS approves MSAs that kind of weren't being honored because when they were paying their doctors, they were paying their doctors at the doctor's bills costs. So, the doctor, bills for $1,000, but, the workers' comp fee schedule says it's a $50 treatment and you only get paid $50 for it, but they're not negotiating those. Doing a professional administration will help with that limitation. And I do know that some claimants counsels that has become a concern with clients coming back to them on full and final Section 32s with that issue. And essentially nothing that can really be done about it because it was the claimant's own fault, essentially.
Yeah, that's a good point. A lot of claimants aren't really sophisticated enough to know that there are going to be differences in prices. Like you know, we always argue the workers' comp fee schedule. It's a little bit less than what the doctor typically charges, which is why you have a lot of doctors who don't typically like to handle workers' comp, because they get less for the same services as billing under regular insurance. Once the carrier goes away and the claimant is sort of just spending this money on their own, they're going to get charged the full price. But having a professionally administered MSA can sort of cut down on the risk of that and make sure that the funds in that account are spent appropriately and that they actually last for the duration that they're supposed to last. And then there's the claim settlement allocation. So that's a little different, but again, you always have to take CMS's interest into account. So this is specifically for situations where there's again no expectation of the person becoming eligible or entitled to Medicare anytime soon, and you get a claim settlement allocation because it creates a future care plan or sort of cost of the medical treatment that considers Medicare interest on cases that have not met the review for threshold by CMS. So this is sort of, sorry, I misspoke. This is for where if the settlement is less than $25,000, like if the person is on Medicare, but the overall expected settlement is expected to be less than $25,000, or they're likely to become Medicare eligible and the overall settlement is not $250,000. So CMS won't review it. You would get a claim settlement allocation that again considers their interests, but it doesn't get submitted for CMS review because the claim does not meet the threshold. The claim settlement allocation will still protect you because it will have, it's very aggressive in making sure that the settlement allocation is both appropriate in accordance with accepted medical standards of care, and that if CMS ever reviews that, you can go back and say, again, we have a reasonable basis for that allocation. So even if it's $0, if you have a reason to back that up, you can still, that will still be considered reasonable, and CMS will leave you alone. So then what do you do if you're not settling? You don't care about CMS, you just want to know what the medical costs are going to be. Well, you could get a future medical cost projection. Those help with things like setting your reserves. It provides a chronological overview of the medical treatment. It can help you identify probable future costs of a claim. It can help you with record reviews, and it is exactly what it says it is. It's future medical cost projection. And it can identify potential areas of cost savings as well. So sometimes you'll get that back and you'll want to act on it based on the recommendations in there. They'll say, hey, again, for example, generic versus brand names. So that can identify that, and you'll want to go ahead and move on that to help lower your reserves. And then we turn to our conditional payment and lien services. So conditional payments are wonky, but they're essentially payments that Medicare makes conditionally. So they'll make the payment, but if they determine that workers' comp is responsible for that payment, they can come back to you for reimbursement. So the services that can be provided in that case, or that we recommend that you secure, are you could do a Medicare conditional payment research. That's where we identify a conditional payment amount or a conditional payment demand, and we investigate that. And if it's appropriate, you can challenge that. And there is also the Medicare conditional payment research final demand. That's where the claimant's Medicare, Medicare Advantage, and Medicaid enrollment is investigated. And if identified, a conditional payment investigation will be performed. Interesting thing about conditional payments, we commonly run into situations where they haven't been secured. We recommend that a conditional payment search, however you do it, that you get it in every case. Because again, if for example, you settle a claim and you don't do a conditional payment search, and let's say Medicare has conditionally paid for $50,000 worth of medical treatment for this claimant. You settle the claim, you don't take that into consideration. 2 years down the line, Medicaid is knocking on your door. Hey, we paid $50,000 for your claim. We want another $50,000. And you had no idea that that was coming up. The conditional payment search will help determine if a conditional payment exists. A lot of times the answer is no, but then you have that certainty that Medicare won't come back to you for reimbursement for that payment. So there are two times where you would want to get a conditional payment search. And again, we recommend them in every claim, but the timing in which you get it is a little different. So you'll get it, there are two times where you should get it. The first time is where you are having the MSA done. You should get that right then because it helps you sort of make sure that the cost of the MSA is adequate. And you sort of want to do that before or while you're getting the MSA, especially if you're submitting for CMS approval, because again, once you submit that for CMS approval, generally that's it. So you get it at the MSA, you get the conditional payment search at the same time as the MSA so that you can resolve anything regarding that conditional payment prior to CMS reviewing it. There is the Medicare conditional payment dispute, and that's where Medicare says, yeah, there's a conditional payment and we want our money back. The conditional payment dispute will be where you tell Medicare, no, we're not reimbursing you. We don't think legally we're obligated to, and we don't think medically that we should have to as well. So use a combination of medical and legal arguments to contest Medicare's conditional payment amount to reduce or eliminate Medicare's conditional payment amount. And I've actually had to deal with this recently. So let's say, for example, you have a claim that's established for the back, and the claimant's alleging a consequential right knee. Let's say they have a right knee surgery. It's not established yet, but they're alleging it's work-related. Medicare pays for that surgery conditionally. If they come to you for a conditional payment reimbursement, you can dispute that, again, using a combination of legal and medical and legal arguments. But in that case, you would say, no, the claim is actually controverted. So you can use the fact that a site is controverted to dispute a conditional payment. In the particular case I was dealing with, the carrier had already paid the conditional payment because, oddly enough, the surgery that we were arguing was unrelated, was done at the same time as the surgery to a related site, because in this case, the person had, one spine, so the neck surgery was done at the same time as the thoracic spine surgery. And we were arguing the thoracic spine was unrelated, but they were billed at the same time. The carrier paid everything at the same time, or Medicare rather paid everything at the same time. So they look at our established neck claim and they see all these records regarding the thoracic spine in our case, which again is not established. They came to us for reimbursement. The carrier paid. This was prior to us getting involved in the claim. We get the claim and we take a look at the conditional payment demand letter, and we immediately recommended an appeal of that. So we are now in the process of appealing, because if we win the appeal, we can actually get reimbursed for the amount they paid to CMS in satisfaction of that conditional payment lien. So just be careful with controverted claims or controverted sites, because there could be a conditional payment for those that Medicare is asking you for. If the site is not established, you shouldn't pay a conditional payment request for reimbursement. And if you do pay it, you theoretically get that back under certain circumstances. So you might want to ask an attorney how to go about seeking reimbursement if you did that. So again, like as I was discussing the Medicare conditional payment appeal, you have to file it by a certain deadline. Obviously, you got to file everything by a certain deadline, but there are appeals. But if it's not addressed, a conditional payment demand converts to a U.S. Department of Treasury collection action. And the one entity you don't want to mess with is the U.S. Department of Treasury. So they're huge. Don't mess with them. But in cases where that happens, we can get involved and sort of help navigate that process. We don't see that too often, though. And then liens. So in addition to Medicaid, you can have, or Medicare, you can have Medicaid liens. There's a Medicare Advantage plan. Research if a lien exists there and whether or not conditional payments have been made there. There's the lien analysis and dispute is sort of similar to what we were just discussing. We would go through and determine what charges should be disputed, and then you file that with the Medicare Advantage plan for their review. There's the Medicaid lien research, which is where, again, you do the same thing with Medicaid to determine if there are any liens that they have. And then the Medicaid lien analysis and dispute, again, if there's a Medicaid lien identified, we'd analyze the demand and make recommendations for mitigating that or disputing that. And then the very simple Social Security verifications, Medicare eligibility inquiries, we can also do that as well. But again, like I just want to point out, while our firm provides all these services, we do have some clients that maybe have their own vendor. We can work with you on an MSA you've obtained from another vendor. We can take a look at that MSA. We can analyze it to make sure that, there's nothing wrong with that. Or sometimes we've seen MSAs where we've identified issues ourselves. I've recently seen one where there was no explanation of the rated age. There was no, there were brand medications included when there should have been generics. So we got the MSA and we said to the client, hey, there are these potential issues in the MSA, which if we submit to CMS approval, will result in a counter hire, which is where CMS comes back with an amount higher than what the MSA is. So we could recommend in those cases taking mitigation action, or sometimes we just request a brand new MSA. And at that point, we can get that. If there are enough problems with the MSA that can't be corrected, you know, we might recommend, hey, just let us do a new MSA. But again, we can work with you with any MSA you obtain. But if you happen to prefer having sort of one-stop shopping, having the attorney who negotiates the settlement also working on the MSA, that's essentially the service we provide. From start basically to finish, we not only work out the MSA, mitigate any costs in the MSA. Once we get it back, if we identify things where the provider could have clarified. For example, a lot of times you'll see their medical records have a list of prescriptions, but you know the carrier hasn't paid any because you've got their prescription fill log and there's nothing on it. Medicaid might be, or Medicare might be paying for those prescriptions, and there may be a conditional payment lien out there. So again, we do things like identify that, clarify those, and once that's all buttoned up, we negotiate the settlement, write the settlement, see it through to approval with the board, and then basically put it to bed and tuck it in like a tiny little baby. So that's essentially why we offer these services. That's what we think we provide that's different from other places. But again, we are willing to work with any MSA statement you have, because at the end of the day, our ultimate goal is to make sure your settlement is approved and that your interests are protected. So however we do that, at the end of the day, we want to make sure your interests are protected. So thank you for listening to my Lex Talk. If you have any questions, you can get in contact with us. Any one of us will be able to help you or answer your question. It might get redirected to me or not. You can contact me directly as well. But any one of us can help you if you have any questions regarding this, or if anyone's telling you any wrong information, you send them my way and I'll deal with them. Which basically involves sticking Shannon Mackey on them. Shannon, anything to add? Any cute little anecdotes? Because you always have an anecdote for something.
No, but when you were talking about mitigating the MSA, I had one. I just knew the claimant was planning on weaning his medications. I think we took the MSA down from like 150,000 to just doing a rough calculation to about 25, because we knew he was planning on weaning, which wasn't necessarily in the record. We just knew he mentioned it at a hearing to the judge because it was his own decision and plan. So, you know, sometimes just looking at those MSAs too can really save money when you're talking about a 32. We probably should have waited to tell everyone he was planning on weaning until after the 32, but it was better for us.
Yeah. So that's all I have. Thank you.
Does everyone have any questions?
I don't see any questions. Nope. All right. Thanks, everyone. Have a good afternoon.